morning. This is Manal from SAIF Zone, and you're welcome to our first economic substance announcement session. And now this does my team's or colleague from DPOs. And hello, everyone, and hello, Brian. And you can start now.
Thank you very much, Manal. And thank you very much for inviting us to make this presentation on behalf of SAIF Zone, or in conjunction with SAIF Zone. My name is Brian Conn. I'm the tax partner at BDO, and I'd also like to introduce my colleague Verona Ho, who's director in the tax group as well. Verona has been working almost exclusively on economic substance for about the last couple of months. So if we have a look at the agenda for today, you can have the next slide, please, Nishi. What we will be doing today is looking at all of the general rules around economic substance. I'm sure a lot of you know the background already, but we're just going to go into the rules in a little bit more detail so that everybody's got an idea of what is required. We'll cover who is actually affected by economic substance, the tests that you are going to have to meet, and the reporting requirements, what you need to do under ESR. And we'll have a question and answer session at the end. Now, you'll probably see on your screen, you should be able to see on your screen, if you want to ask a question, you can type it in. Our moderator, Nishi, who is another one of our team, will record all of those questions and we can answer those at the end. Also at the end, you'll be able to raise a hand. So if anybody wants to ask a question live, we can do that as well. Okay, so let's move on. Let's talk about what economic substance regulations are all about. Very briefly, they were introduced in response to work that has been done by the OECD and other organisations over the years to combat international tax avoidance. And the essence of the ESR is that if a business is set up in a particular jurisdiction, it should have the people, the resources in that country to operate the business. And if you can prove that you have, then there's absolutely no problem. ESR applies, as it says there, all accounting periods starting on or after 1st of January 2019. Right, thank you. Go to the next slide, please, Nishi. Okay, who does ESR apply to? Well, the law says is that the ESR applies to every licensee carrying out a relevant activity. Now, the law talks about licensees, and what it means by licensees is anybody who has a trading license in UAE. So any sort of entity, onshore, offshore, mainland entities, free zone or non-free zone. So it's very broad. Any licensee might be affected, but they only are dragged into the full scope of ESR if they're carrying on a relevant activity. And we will talk about what a relevant activity is in a moment or two. There are very few exemptions. So entities that are government owned, 51% or more are exempt, and businesses that are not actually earning any income at the moment, dormant businesses, for example, are not obliged to make any, are not pulled into the full scope of ESR. Okay, next slide. Right, I mentioned relevant activities. The relevant activities are essentially 9 broad headings, types of businesses that are affected by ESR. And the headings are there: banking, insurance, fund management, lease finance, headquarters, shipping, intellectual property, holding companies, and distribution and service centres. So just those headings are affected or are within the scope of ESR. We should mention at this point there is some very good guidance on the Ministry of Finance website as to what is meant by these relevant activities. So if you haven't had a look at the MOF website yet, have a look at that. There is some good information there, and it's quite straightforward information, good, easy to read information. Okay, if we go to the next slide. What I would like to look at now is just a description of some of these relevant activities, just to explain what is meant by them. So we won't look at everything, but we'll just look at some of the main ones that tend to come up a lot. So holding companies, there are some special rules for holding companies, and Verona will talk about those later on. But essentially holding companies, they're talking about businesses that just hold shares in other companies. So effectively passive businesses that hold shares, receive dividends, possibly dispose and make capital gains, but they're not actually trading, they're just receiving passive income. Headquarters businesses, this is effectively businesses that provide at a high level services to other foreign group companies. So they might be providing senior management to guide and form policy and assist the rest of the group at a high level. It doesn't need to be the ultimate parent company, could be anybody in the group, but it's the type of service that is concerned. Distribution and service, excuse me, distribution and service centres is actually two types of relevant activity. Distribution involves purchasing goods from foreign related parties, importing those goods into the UAE and then exporting some of those goods. So it's quite a specific type of activity, and it has that international aspect to it. Service centres, again, it's looking at international services where companies are providing services to foreign related parties, and this is generally backup services like IT, accounting support, that sort of thing. That's the sort of thing they're looking for under those headings. The next headings, lease finance. So this is financing assets, and it could be either third parties or group financing as well. One important thing to say here is that it doesn't include property leasing. We have lots of questions from businesses as to whether or not leasing property is covered under this heading, and it's not. So that's an important point to remember. Shipping is an important area. When I first saw the heading shipping, I assumed it would mean all sorts of logistics, moving goods about. It does actually, however, focus on actually owning and moving goods with ships, goods and passengers with ships. So it's not businesses that are not actually operating shipping. Intellectual property, a lot of businesses will hold intellectual property, even if they don't see themselves as intellectual property businesses. So an intellectual property business for these purposes is anybody who holds, exploits or generates income from IP assets. So if you're getting royalties, licensing fees, franchise fees from group companies, you are into this area. There are special rules for high risk intellectual property companies. Verona will talk about that in a little bit more detail later. The reason there are special rules for that type of company is that this is particularly an area that in the past some businesses have used for avoiding tax internationally. So if a business carries on any of these relevant activities, It then falls within the scope of the ESR, and it has to consider whether it can meet 3 tests. And the 3 tests are whether or not there are core income generating activities, what the law calls SIGA, in the UAE, whether those SIGA are managed and directed in the UAE, and whether there are adequate resources in UAE. Now, just a word or two about SIGA, and Verona will talk in a bit more detail in a second about this. But SIGA is basically the activities, the parts that make up the relevant activity as a whole. So, you know, as a banking business, for example, you might grant loans. That would be the SIGA. And you have to look at each of those SIGA individually in order to establish whether you meet the tests. Now, I'm going to hand over to Verona now, who will look at those tests individually in a bit more detail. Verona.
Thanks, Brian. So we'll touch on all 3 tests throughout the presentation. So I'll start off with what a SIGA in UAE means. Brian has given you some broad ideas of what a SIGA is, and it's effectively what he has mentioned. What are the central activities which are important for those relevant activities that you have identified in the first stage? So an example that we have is if you're a distribution and service center business, what we will expect to see as one of your core income generating activities in UAE could be transporting and storing component parts, materials, or goods ready for sale, managing inventories, taking orders, and if you're a service center business, simply providing consulting or other administrative services. This may differ from relevant activity to relevant activity. If you're talking about lease finance business, say you have provided an intercompany loan, a core income generating activity from UAE could be simply agreeing funding terms. So we need to look at your business as a whole, or as an individual business, because even the law says or gives examples of what they expect a SIGA to be within a relevant activity. They use the term include. So it could, any of your activities that are not falling under the interpretations of the law, or at least the list provided within the legislation, could still be considered as a core income generating activity. And we need to ensure that these activities are done from the UAE in order to meet them. Nishi, can you flip? Yep. So the next test that we need to ensure that you comply with to prove substance here in the UAE is directed and managed. This is, they do give very broad views of what they what are the tests to actually fulfill a directed and managed test. We have listed them on the slide. One is having adequate board meetings in the UAE, ensuring your quorum is present for those meetings in the UAE. This is where we see a lot of companies struggle with, because this not necessarily lines up with what they've always done, which will be virtual meetings that were always done before ESR was introduced. Another important aspect is to ensure that all these meeting minutes are recorded, signed by the members during the meeting itself in the UAE. So records of those meetings are very important, because this is what you will be providing to your regulatory authorities, so SAIF Zone, to prove that you were directed and managed in the UAE. These are documentary evidence that you need to maintain. You need to ensure that the directors that you have appointed have the knowledge and expertise to discharge their duties. So they need to have the experience to manage the company and take directions for the company. And the last point is very important. If your entity does not have a board of directors, so if the license you hold does not require the appointment of a board of directors and only a single manager is there, that manager should be a UAE resident, and there should be evidence that he has the power of attorney to take decisions for your company, and he also signs off on the resolutions of the SIGAs in UAE of that relevant activity. So, okay, so I'll move on to the next test. So when we talk about having adequate resources in the UAE, there are three parts that we look at. The first will be whether or not you have adequate number of full-time qualified employees in the UAE. There is no set number that they have prescribed within the legislation. So a common question that we always get is whether 1 employee is enough, whether 10 employees is enough, or if I have 100, whether it's enough. There is no set threshold within the legislation. There might be guidance coming up in subsequent years on what is deemed to be sufficient for a certain size or type of business. But that is something that we probably will not get by the end of this year. But you as a business will need to substantiate what you feel as a business is an adequate number of full-time employees to do the work or to execute the relevant activities of this that you have identified. Then the second point is having adequate operating expenditure in the UAE. Again, the definition of adequate is not defined within the law. It doesn't say that 100% of your operating expenditure must be in the UAE, but we expect that you will need to take a reasonable approach where a significant or key expenditures of your SIGAs of the relevant activities needs to be incurred in the UAE. So if you outsource any of your activities to outsource service provider outside UAE and there are key aspects of your operations, you might have to reconsider that. I'll talk about outsourcing in the next slide. And the last point is having adequate level of physical assets in the UAE. Again, adequate is not defined, but we expect that what you will need to operate your business, you will need to have in the UAE. They need to be physically present here. So this slide talks about outsourcing arrangements. So when I mention resources, adequate resources in the previous slide, the law allows you to outsource. There is no restrictions of outsourcing, but it also means that there are certain conditions that outsource service providers and you who are outsourcing these activities will need to fulfill. The first is that the outsourced service provider must be conducted in the UAE. So if you remember my previous example where I say if you outsource key activities outside UAE, you might have to rethink that. They might have to be onshore back into the UAE and you might have to ask your service provider about this. You will also need to ensure that your service provider has adequate activities, employees and expenditure and premises in the UAE to provide you those services. And you need to ensure that you supervise and control all the core income generating activities that you do outsource. An important point is that there should be no double counting, and that's very important. What it means by double counting is if your service provider services more than 10 companies with 2 people, they need to prove that these 2 people can service those 10 companies and in what capacity. So you will need to obtain this information from your outsourced service provider if you do outsource. So now that we have talked about the test, if you recall when Brian was presenting earlier, he was talking about how there are special conditions for holding companies. So we talked about, the 3 aspects of the test, and now we're talking about special conditions with regards to certain relevant activities. The first is a holding company. So holding companies are primarily companies that only hold equity interest. If you do anything outside holding equity interest, you fall outside the holding company's definition. If you are a holding company, the good news is that you have reduced requirements. So all the tests that I talked about, they become easier to fulfill. Well, it means that you just need to comply with the laws applicable to the licensee in the state. So you need to meet all SAIF Zone's requirements with regards to the license that you hold. You need to ensure adequate employees and premises, but what they mean by that is also they will consider directors to be employees, because if you're only a holding company, it's unlikely that you will need a large you will need sometimes more than 1 or 2 employees on the payroll. And because of this, they do consider directors to be considered as employees. And they also considered registered offices of flexi-desk arrangements to be deemed premises. So you don't necessarily need a tenancy contract to prove that you have premises in the UAE if you're a holding company. So going from a reduced substance requirements, now we move to something that has additional substance requirements. So an IP business is someone who holds, exploits, or receives income from intellectual property assets. But it becomes very important if you do fall under the definition of IP business, you have to further look on whether you are considered high risk. What we mean by a high risk IP business is if you did not create your IP and you acquired it from a group company or in consideration for funding R&D in a foreign jurisdiction. So you have bought it from a group company, or you have paid someone, you have contributed to the funding of the development of the IP, but in a completely foreign jurisdiction outside UAE. And you receive income from group companies in connection to this IP asset. So what if you are in high-risk IP? What's the implications for ESR? What happens then is that you are deemed to have failed the standard ESR test. The 3 tests that I talked about earlier, you will have deemed to have failed it, and the regulatory authority SAIF Zone will need to provide this information to MOF, which will also share it with foreign tax authorities. In order to consider yourself meeting the test, you will need to prove that you had a high degree of control in the development, enhancement, maintenance, protection, and exploitation of the IP in the past. You need to show business plans of why you're holding it here in the UAE and not anywhere else, and provide detailed employee information with regards to the development of this IP. So it's very important to note that if you do fall under this IP test, you need to first check that you are a high-risk IP and whether or not you do meet the additional tests. So that covers generally what you need to do if ESR applies to you. Now we move on to what all licensees need to do with regarding to your reporting requirement. The first reporting requirement that every licensee in SAIF Zone will need to fulfill is submit your annual notification by 30th June. The portal will be up for you to submit it, I believe, by Monday, and guidance on submission will be provided then. What the contents of the notification is, you will need to indicate whether you do a relevant activity or not. And if you do a relevant activity, whether the income that you have received from that relevant activity in the financial year, whether it was taxed in any other jurisdiction, and also your relevant financial year. There are some other management information required about that, but these are the key things with regards to ESR that you will need to notify. If ESR applies to you and you have indicated relevant activities that you have executed during the year, your next obligation will be ESR reporting. ESR report is basically you telling your regulatory authority SAIF Zone whether or not you have met the ESR test during the year and how. This reporting is due 12 months after the end of your financial year, which means if your financial year is 31st December 2019, this report is due 31st December 2020. We have provided this flowchart, and this flowchart is actually adapted out of MOF. This presentation will be provided to you later on, and you will have access to this flowchart. But effectively, this is a walkthrough process on how you determine your reporting requirements and what you need to do at each step. A point to note is ESR notification you will see is right after whether or not you conduct a relevant activity. That should actually be moved up one step because every other licensee will actually need to notify whether or not you do a relevant activity. We have not changed this because this was taken off the MOF website, but that's something that I need to clarify. So whether or not you do a relevant activity, you will need to submit this notification by 30th June. Next slide, Amrita. Okay, so the last thing that we need to cover during this presentation is the consequences of non-compliance. So we're talking about penalties. The implications are quite significant because this is a very important regulation for the country as a whole. And these penalties have actually been indicated by MOF. And if you check across every other regulatory authority, this is consistent throughout. So if there's a failure to submit the notification by 30th June, there's a potential penalty of 10,000 to 50,000 dirhams. If you have failed to provide accurate or complete information, there's a penalty of 10 to 50,000 dirhams as well. And they will have deemed that you have failed to demonstrate economic substance in the UAE. So it's important that whatever that you have provided in notification and reporting is correct. And the failure to demonstrate sufficient economic substance for the first year, your penalty is 10 to 50,000. And they will provide the information to any foreign competent authorities of your parent company's ultimate parent company and ultimate beneficial owner. And if you fail it more than 2 years onwards, they will exchange the information. There is an increased penalty of 50,000 to 300,000, and they could potentially even suspend your license or opt to not renew your license. So they are very heavy penalties, and this emphasizes the importance of all licensees implementing ESR regulations correctly. So overall, that covers our presentation. We'll move on to Q&As. Amrita, Nishi?
Yeah, so the floor is now open to have your questions. And Verona and Brian, we do have some common questions. So I would just elaborate on those. So the two common questions that we received so far was in terms of a company having a freight forwarding service license, but let's say they do not own the vessel, they do not, operate the crew members on the vessel, and they don't, they basically use the third-party services for any kind of activities on the ship. Will they still fall under the shipping category? This is the most common question that we have received so far.
Brian, do you want to take that? Brian, should I take that or should you? I can't hear you, Brian. I think you're on mute.
Nishi.
Yeah, I think we just lost you, Brian, at the beginning. Could you please repeat?
Yeah, okay. Verona, yeah, could you take that, please? Sorry, there was a problem with my microphone.
Oh, okay, sure, no problem. Generally, shipping covers the operation of the vessel itself, and it does include the management of the crew. So if it's completely outsourced to a third party, I wouldn't think that you actually fall under the shipping conditions. The shipping definition is very, very specific, and it does say that it involves the operation of a vessel.
Yeah. Another common type of questions that we have received is in terms of businesses who are dealing in trading of goods, and let's say if they are buying from some countries outside UAE and the goods never touch the UAE soil, would they still be required to file the ESR notification?
If the goods never fall on UAE soil, it shouldn't, because the definition of a distribution service requires the purchase from a foreign connected person, importation into the UAE, and subsequent export. So if the goods never arrived here, you don't fall under the distribution definition.
Right.
Yeah, I think it's worth everybody who is in that type of business having a look at the rules that are set out on the MOF website, because it is actually quite specific about what is covered and what isn't covered, and those two elements in particular, that the purchase must be made by the from a connected party, and the goods must come into the country, are very important.
Right. So we have a question from Mr. Karim. Karim, I'm just going to put you, I'll just unmute you so that you can just address your questions, please.
Hello.
Hello, Kareem.
Hello.
Yes, can you hear me?
Yes, we can. Thanks for logging in.
So
How can we
thanks.
help?
On the importation of goods, I have a couple of questions actually. You mentioned that the goods that don't touch the UAE are not subject to ESR regulation, I guess. Is that
Yes.
right?
Yes,
What about
that's
the
right.
goods? What about the goods that come into the UAE but into the free zone and then they're re-exported? They're not actually imported into the UAE as such. Are they subject to ESR regulation?
Verona, can you take that one?
Sure, no problem. Yes, even if it comes into the free zone, it's considered imported in the UAE. I know that if you're talking about like from a VAT perspective, we do have a distinction between a designated zone import and import into the mainland. But for ESR purposes, there's no clear distinction. So even if it was imported into a free zone, it's considered imported into UAE.
Oh, I see. Okay. Other question I have is there any value, minimum value that you can do your business in which are not subject to ESR, or it could be any value, even 1 dirham of import?
Well,
Unfortunately, there's no threshold.
yeah, it would make sense if there was some minimum level, and maybe actually in the future that will happen. But unfortunately at the moment, as you say, just 1 dirham would put you within the scope.
Okay, I've got 2 more questions if you don't mind.
Okay.
Sure.
Okay, one more question I have is that the one point you mentioned about the importing of goods. What about if the goods are bought in the local market and either resold in the local market or exported out? Are they also subject? Yes, sir.
That in itself shouldn't be a problem. I don't see any issues there. Do you, Verona?
No. So, sorry, I got the connection actually blocked out in part of your explanation. I just want to confirm. So it's bought from the local market and subsequently exported out. Am I right?
Well, there are 2 points here, either exported or resold in the local market.
Okay, so if it's resold in the local market, it shouldn't fall under ESR. But if there is any line of products that you have bought from a related party overseas, imported into the UAE, and subsequently exported, that captures you under ESR. But if all you do is resell into the local market, you fall outside the scope of ESR.
Okay, great. Okay, I think if and you know, in terms of this ESR, I have one more question. If you have activity that is that falls within ESR, but for the last 1-2 years, there's been no activity at all, literally, and we are eating through our pocket at the moment. How would you define that? Let's say we had some activity last year or the year before, but nothing now. But obviously we're spending money here, we're living here. Would we still be subject to ESR?
You wouldn't. You would be in a position where you might be carrying on a relevant activity, but you have no income
Yes.
in the relevant financial year.
Okay.
So you will need to make the notification, say that I have no income from relevant activities. And in future, obviously you might fall into it. But it is about actually generating income from those activities. Anything you want to add on that, Verona?
Yeah, it's also important to note that for this notification due 30th June, it's for financial year starting on or after 1st Jan 2019. So for most companies, we're actually looking at the 2019 year. So you will need to look back instead of what you're doing right now for this notification. Okay. For next year's notification, you look at this year.
Okay, so for the year 2019, we should notify by June this year, right? June 30th.
Yeah.
Yes, that's right. That's right. And it's that year you're looking at. So if there's no income in that year, that's fine. But as Rona quite rightly says, make sure it's you're looking at the correct year.
Great. Good. Okay, thank you very much. Thank you.
Okay, thank you, Kareem. Nishi,
Thanks, Kareem.
what else do we have?
Yeah, we do have other questions. So I am now moving on to Abdul Karim. He has raised his hands. Abdul Karim, can you hear us? I've just unmuted you. You can ask your question, please.
Thank you. My one suggestion to SAIF Zone is, can SAIF Zone send a notification to all the license holders who fall under the category that they should submit the ESR? You got my point?
I think that there is the problem with that is that it needs to be the licensee itself needs to make the decision. One of the points is SAIF Zone won't necessarily know because you can't, for example, go on what the trade license says. It's what the business is actually doing, it's substance over form. So unfortunately, the first stage can't come from SAIF Zone. It is up to the individual businesses to make that decision. Unfortunately, it would be nice if we could do it that way. Manal, did you want to make any comment on that?
No, it's exactly what you said. I was going to say the same.
Okay, thank you. A good question, and it's a good point to raise. But
the thing is, can I continue, please?
Yes, of course.
One thing is that when SAIF Zone issued the license, they know what are the activities that license holder is supposed to do. So they should have a database so that they can also follow it up. Yes, this company is not submitting ESR, or this sub company is supposed to submit this ESR or not. That's a suggestion from our side. It becomes easy for others not to make unnecessary queries to SAIF Zone or go to the auditor whether I fall into this category or not, because activities are confined as per the license only.
Yes, sorry.
Yeah. No, it's okay. It's okay. Can complete.
I was just saying, it's a good suggestion. We do take it on board, but the problem is that on occasions businesses will do things that are not specifically or clearly covered by the license, and therefore the businesses have to answer for themselves. SAIF Zone will be in touch with businesses that haven't. It will take a note of those businesses that don't notify. But unfortunately, the first notification does have to come from business itself.
Okay.
Okay, but thank you for that contribution, and I can fully understand where you're coming from.
Right. So we have the next question from Anand. Anand, can you hear us? I think there's some issues. Anand, can you hear us? Would you like to ask your question, please? Okay. I think he's facing some troubles. You can definitely drop in your question in the question bot. I will now move on to Mr. Amit Kumar Singhal.
Is there any customer service center in the SAIF Zone? Like things seems to be very complicated, and everybody is too disturbed with the current situation. So to make it more easy, is there something in the free zone that one of our employee can go and sort out what all is the procedure actually? And is there any fees for this applying for this ECR?
To take those things in reverse, there's no fees for making you notification. In terms of information coming out, very shortly, SAIF Zone will be posting frequently answered questions and information on the website. We'll also be publishing these slides and a copy of the presentation. So there will be resources that you can log into on the SAIF Zone website, and we're expecting those to be available, I think, around the start of next week. Also, from the start of next week, you will be able to log on and make the notification, and there will be instructions on how that notification is to be made. The other place for information, as I mentioned before, the Ministry of Finance website is actually quite good, and there's some quite useful information on there as well. But it is a difficult subject. And I think after this first year, it will be a lot clearer to everybody. But we do realise at the moment, a lot of people are struggling just to understand what's happening. Anybody else want to add anything to that I might have missed?
No, nothing else from my end.
Okay.
No,
okay.
nothing else.
Okay. Thanks for the question, though, Ahmed.
Right.
Nishi,
So,
any more?
yeah, we have quite a number of questions actually. So now I move on to Avinash.
Hello.
Hi, Avinash.
Hi. My question is regarding the applicability of ESR for the intellectual property rights. So a SAIF Zone company, it is the owner of certain brands. It is into pharmaceutical products. It is owner of certain brands. So another group company from India, I mean, the SAIF Zone company buys the goods from another company in India and sells to another group company in Ukraine. Goods never touch the shores of UAE. But the goods which we are now talking about are the brands which are owned by SAIF Zone company. So in this case, whether the ESR, does it fall under the ambit of ESR activity? If so, is it a risky, something what you told is a high risk activity? That's all.
The high risk IP business. Yeah. Now, firstly, the goods themselves, they're never entering the UAE. You were saying.
Yeah.
Okay. But so that part of the activity, it's not a distribution business. As for the IP, do you make a charge? Do you receive any income from any group companies for use of the trademarks that you have?
That's not charged separately, but that is charged. That is factored in the cost of the product.
Right. You see, you only become a high-risk IP business if you're actually generating income from those brands. But if there is a fee within the cost charge of for the products, are you selling to related parties, or are they all third-party sales?
Both the selling and the purchasing activity is done from related companies.
Okay, so you're selling to related parties as well.
Right.
Yeah. Okay. Verona, do you have any thoughts on that?
I just have a couple of questions as well. So for high-risk IP, not only you need to generate income from related parties, you need to have purchased that asset from a related party as well. So we kind of need more details. How did you come to hold those brands?
Right. I did make a note of that when you were telling that. So these brands were not created by the SAIF Zone company. These are acquired by a group company.
Okay.
Acquired
And
from group company.
All right. And did they sell it on to you in the SAIF Zone company?
Yeah.
So the group company bought it from a third party, and then the SAIF Zone company bought it from the group company.
Correct.
Yeah, I would say like from a very high level perspective, it does seem that you could potentially be a high risk IP.
Okay.
I would agree with that. That there is an element in there. It's not quite as clear as some cases because the law expects that probably you will actually be receiving a license fee or something. But I think there's probably a license fee embedded in the sale price to the related parties, and I think that probably does create therefore a high risk IP business.
All right. So I just wanted to make this point clear that there is no income generated for the use of the brand name, but of course the selling prices are include the the brand cost.
Yeah, it's actually quite a difficult question. That's maybe one we should talk about offline. But I think, in essence, I think you're certainly in the danger area there.
All right. Okay. Thank you. Thank you. Thanks.
Thank you for the question. It's a very interesting question.
Thanks, Avinash.
Thank you.
Yeah. So while I move on to the next bunch of attendees who have raised the question, I have just a quick question which I believe would answer, provide answer to a lot of questions we've received. It's regarding the intercompany recharges. Will that is that something that is going to get covered within ESR? These are very common questions that we have received. Intercompany recharges, intercompany transactions around the globe. Is that something that will be covered within ESR?
It's probably something that's covered under service centres. Do you want to pick it up, Verona?
Sure. So intercompany charges, the two most common relevant activities that might apply would be headquarter business. If you do an intercompany recharge for management services, or if you're a cost center and you're recharging your admin support costs, whether with a markup or not, to foreign related parties, you fall under service center business. But if your intercompany charge is local, then you don't fall under ESR because both of these relevant activities requires a charge to a foreign connected person.
Right.
Yeah, hopefully that will help with that one. And it is that point, if it's an international group and you're making the charges overseas, then you will almost certainly fall into either headquarters or service centres.
Right. So I now move on to Mr. Shrey, who has just raised his hand. Shrey, can you hear us? I think there's an issue there. So I'll just move on to the next attendee. You can definitely write to us and we'll address the questions later. Shahid,
okay.
We have a question from Shahid.
Okay, Shahid, good to hear from you. Can we have your question?
Okay, so I don't think so. Again, there's some technical issue, but I can just summarize his question for you. So he's basically asking if the company is a trading company and if it is not purchasing from any of the connected company, is that something that will get covered within ESR?
Generally, no. For the distribution businesses, it does rely on purchases from connected parties.
Right.
Verona, anything to add on that?
No, nothing. You need to buy from a foreign connected person to fall under distribution. If you just bought it from a third party, you don't fall under the definition.
The essence of all these ESR tests, or most of them, is a question as to whether or not any profits have been shifted by buying and selling things with connected parties, and that's why in many of these cases it is an issue as to whether or not it's a charge from someone to or from a group company.
Right. So Brian, do we have some time to take the last question here?
Yes, absolutely, absolutely. Who have we got online?
We have Rehman Shahzad. Rehman, can you hear us?
Hello, hi. You can hear me?
How are you?
Yes, we can.
Thank you. Thanks for wonderful knowledge and your answering questions. Answering all the questions. I have two questions actually. The one is like if two licenses are independent, but the owner is same, and two companies are in different countries. So still this law regulation will apply.
If you have it's a UAE trade license, then you have to report. So yes, it applies. And if you've got more than one license, you have to do more than one report. So if you're branches of a different of an entity in different free zones, say with different licenses, you would have to report for each license. So it's by license really.
Sorry, you mean to say that if licenses are even independent, like my question was that if there is no parent or subsidiary relationship, like on the parent trade license, it's not mentioned this is a branch, but both companies are independent and they have their own license. So still this will apply?
Well, what Brian is trying to say is it doesn't really matter whether or not it's a parent subsidiary relationship or a branch and headquarter relationship. Whichever license you hold in the UAE, you will need to self-assess whether ESR will apply to you. And if it applies, each of these licenses will need to meet their own economic substance test. So when the notification platform is launched, if you hold more than one license in SAIF Zone, whether or not they're within the same group or the same owner, you will need to file one notification each. Does that answer the question?
Yeah. Thank you so much. And my second question is this: like as you mentioned, if goods will not touch UAE soil, and there will be no regulation. But if this is like mixer, some goods are dispatched directly, and some are come on the UAE and then dispatched from here. So what will happen in this case?
Yeah, so as soon as you've got any goods that are falling into that category where you've bought them from a connected party, they come into the country and exported, even if only some of those goods are exported, then you're falling into the ESR. So it's like someone was saying earlier, there's no minimum limit. So if any of those goods are then exported to a connected party, then you're falling within the rules.
Yeah, thank you so much. And in this case, we will report full revenue or just part of that which you received in UAE, and the rest is virtual.
Rona, do you want to catch that one?
I didn't get the question, unfortunately. Could you repeat the question?
So as I mentioned that there are two types of goods, like some material didn't touch the UAE, but still we are doing invoicing and actually dispatching directly. And the second, we receive goods in UAE and then we invoice and export. So now there are two kind of revenue, one for the goods received in UAE and the one which was directly dispatched. So when we will do reporting, we will report full revenue or the only portion from the goods received in UAE.
Only the revenues from the ones that meet the requirements of economic substance. So if only the line of goods that you purchase from a foreign related person that arrives in the UAE, imported into UAE, whether in the free zone or mainland, and subsequently exported. any shipments that you're doing directly from outside UAE and never touches UAE, you don't need to report the revenues, the authorities for ESR.
Okay, thank you. Just last question related to reporting. When we will have any format from SAIF Zone, that how we will have, how will we report them? They will give online options, or there will be any forms, or they will send some requirement that this you have to submit. What will be the process? Reporting.
Yeah. So the link to make your report will go live early next week from SAIF Zone, so you can start to report from next week, and that will all be done online. So there's no forms to fill out other than the online form, and there will be full instructions on how to fill it out. And the first notification, once you've decided whether you have a relevant activity, is a fairly straightforward form. There's not too much detail that has to go on there, but that will all be up and available next week.
Okay, thank you so much. Thank you.
Okay, thank you very much for your
Thanks,
questions
Kamal.
as well.
Yeah, so now this brings us to the end of the Q&A session. I just want to highlight that the material that was presented today will be shared with all the attendees, and you can definitely share your questions later. Over to you, Brian.
Okay, well, thank you everybody that attended, and thank you for the questions. Sorry we couldn't answer probably everybody's questions, but hopefully we've answered broadly everything that everybody needed to know. Thanks, Verona, for joint presentation, and Manal, and we hope to hopefully next time we can all meet up face to face. It's difficult doing things online, but hopefully you found this useful. So thank you very much indeed.
Thank you, Brian. Thank you, Verona. Thank you.
Thank you, everybody.
Thanks, Manal. Okay, bye.
Bye.